So it doesn't happen often that somebody you call out for being corrupt, someone you call out for being part of the problem in state government, is actually willing to sit down and talk with you. And so as we welcome to the studio today Representative Todd Rutherford, the Minority Leader of the South Carolina House of Representatives, member of the Judicial Merit Selection Commission, I want to first thank you for being willing to sit down with us, because I will say it takes a lot of courage for you to be willing to do that.
But it doesn't. Like, when you don't do anything wrong, I don't need courage. I've seen you in court. I've seen you in coffee shops. Every time I do, I come up and talk to you. I believe that the press plays an essential role in this process, and I've always believed that you are part of that process. And so I appreciate you asking me to be here.
Well, fair enough. Well, I will point this out. It will take a little courage for me, because you are a hell of a debater. I've watched you not only in court, but I've watched you in legislative hearings slice and dice some of the smartest folks out there. So
for those of you that don't know, Will and I go back to when you was a staffer, and that's a long, long time ago, and we had a lot of hair back then and don't necessarily now. But I appreciate what you do, and I think that, again, you play a valuable role in this process. So,
well, let's dive right into this, because, you and I obviously come from different sides of one of the biggest issues facing this state, which is the issue of judicial corruption. But before we get into that, I wanted to address something that you and I have talked about offline, something that this news outlet exclusively reported earlier this year. And we did reach out to you when this news broke, but I wanted to address it with you here. The reports that you are currently under a state law enforcement division and potentially federal investigation related to any number of financial matters. But would you like to address for us, Mr. Leader, those allegations?
I can't wait, and that's one of the reasons why I came here. The word bullshit comes to mind, and I realize that I'm a politician with a microphone in front of me. I should not be using profanity, but I am not under any SLED investigation. I'm a criminal defense lawyer. I go to SLED. I've been to SLED multiple times for any number of cases. I go to the Richland County Sheriff's Department, to CPD, to Lexington County, all the time. This is what I do as part of the process in Chester Sheriff's Department, to look at a police car. This is what I do as part of the process. Whoever is feeding that information is making it up based on my presence, no different than me being here at the super secret Fitz News studio that I didn't know existed. And somebody sees me leaving here and goes, oh my God, what was he breaking in there? But again, not under any SLED investigation, received no target letter, received no phone call from them, still do investigations where they are investigating my clients, and I am talking to the investigators on those cases, some of them public corruption cases involving police officers or elected officials in other places. So again, I don't know what someone is taking and trying to make into them investigating me, but as you know, I have lived my life out loud for the past 25 years. Everything that I've done in state government, you can go back and look 25 years ago and find it. There's a record of it, from earmarks to anything else. Anything that I've ever done is out there. I've been audited by the IRS a couple of years ago. They came and set up shop in my office. It was a lady, I believe, named Karen. She set up shop for like a week here and a week there, looked over everything. There's nothing in my finances that I do illegally. There's nothing that would incur an investigation. It's why I'm willing to come and talk about it, because I don't do anything wrong. I am the one that, when SLED needed $52 million for their new, grossly outdated, way too expensive laboratory, I'm the one that said no. I'm the one that asked the General Assembly to take away the salary of the head of the Highway Patrol. I'm the one that continues to tell us that government is getting too big, that government has too much information, and believe that the tip of the spear is law enforcement in that community, because they are growing with what they have on us as individuals. And the reason why I'm able to do that is because I don't worry about somebody looking into me.
Well, let me ask you this, though, because I appreciate you're on the record with that, and thank you for doing that. But let me also push back a little bit. We don't pull this stuff out of our ass.
Well,
we got very credible law enforcement prosecutorial sources, and there was clearly, hold on.
Go ahead.
There was clearly a referral made to law enforcement related to some items in the budget, earmarks that benefited folks very close to you, family members. So that was, again, according to our sources, the origin of the inquiry. But you're telling me nothing to it.
I'm not only telling you that if that's the origin of the inquiry, whoever sent it over there and said, hey, look into this, again, people not knowing and understanding the law and understanding the budget process, if SLED had gotten that referral, they should have kicked it back and said, you need to go and read and understand how this works. The earmarks that I have done that went to a person that was not a family member of mine at the time, she is now my mother-in-law, but she was not then. She was a counselor that handled had women that had children in high school trying to stop them from getting pregnant again. It was an ongoing program. We earmarked some money and sent it down there. She used that money for what it was supposed to go to. The Post and Courier, the state, and everybody looked into it. It was proper at the time. I could not do it now because the law would not allow it to happen. However, it is nothing that I've ever done. There is nothing that I've ever done at the State House in my role as a legislator or my role as a lawyer that is illegal, because if there was, these same people who I've stood in the way of and told that they have too much power and they're getting too big would not hesitate to call me to the carpet on it.
Well, let's lean into then the broader issue, and I appreciate you being willing to address that. Moving away from the individual allegations, I wanted to play a clip for you about this bigger corrupt network. And I think whether or not you're involved in that, we'll debate that in a second, but I think we can all agree this system has some problems. And I wonder...
Hold on, the nomenclature that suggests that it's a corrupt network, before you even play the clip, and I don't know what you're playing, but I'm not necessarily agreeing that that's the nomenclature that we're going to use, but go ahead and play
Fair
the clip.
enough. Yeah. And I want to point out, there's Republicans who have criticized you, Republican solicitors. There are a few Democratic solicitors who have criticized you, but this is a member of your own party from the well of the Senate earlier this week. And I wanted to play this clip about the committee that you are one of the ranking members of, one of the longest serving members of, one of the most influential members of. And this is what a member of your own party had to say about it. Let's take a listen.
Many of you, I'm sure, noticed that we've got a report this morning in our boxes from the JMSC on their newest round of hearings and determining, and it was a draft report. And what was amazing to me, I've been following this issue, if you haven't noticed, the JMSC and whether or not we should reform it, is that at least in one instance, and I think I've counted 4 different violations of the law by the JMSC, 4, and it's a fascinating story. There was an incumbent circuit judge named Bentley Price, and Bentley Price was opposed by a guy named Brent Halverson. I've met Mr. Halverson, very nice guy. I know Judge Price, very nice guy. I don't have as we say, a dog in this fight. But what I do have is an interest that this process be conducted in an apolitical, fair fashion, and this did not. Price had a number, apparently, complaints, and as a result, could not garner the votes to get recommended. There was a vote held according, now in this report, there's no vote recorded, but members of the JMSC told the Post and Courier that he got a 5-5 vote, which is not enough to be found qualified. As a result, he withdrew. So it left Mr. Halverson. Now, Mr. Halverson, under the statute, what happens is when an incumbent judge is found not qualified or withdraws, there's no election. It's carried over, reopened, people can apply. But apparently, because Mr. Halverson had the gumption to run against an incumbent judge, the JMSC went out of their way in breaking the law to find him not qualified. Now, they couldn't find him not qualified without a vote, and the vote has to be recorded as to who voted how. No vote. And they made findings based on my knowledge, not based on facts. So what happened is, because he had the gumption to run against an incumbent judge, the Merit Selection Committee, and that really is a misnomer, Merit Selection Committee decided to gut him, to find him not qualified. And ladies and gentlemen, we have pending in Judiciary Committee 3 separate bills that would at least begin the process of discussing this. This report is an abomination. It's a violation of the law. And as somebody who practices in front of judges, I got to tell you, it scares me that these folks are the ones that decide who gets voted on by us. So I bring this to your attention this morning because this is an abomination. This is an outrage. It's a violation of the law. These are legislators breaking the law to pick the people who will interpret the law. I mean, does it get any more dystopian than this? So please, let's do something now about changing this process. And let me say this to you. I'm not for the governor appointing. I'm not necessarily for all lawyer legislators being eliminated. There are things we can do that will change this process, make it fair, more transparent, more open, and give all of us and the public confidence that the people that are picked to judge and interpret the law are picked based on their ability, not on who they know. Thank you.
So I'm laughing while you're playing it because the battles that I've had with this individual that you say is a member of my own party, but I don't believe that applies to him. This is someone that ran under the pretenses of a fraud. He told the world that he was going to run. This one time he was just going to get in there and shake things up, and he wasn't going to run again. And now all of a sudden he's announcing he's running for re-election. So again, let's start off with the fact that this is someone who induced people to vote for him, people like me, because he's my senator, induced people to vote for him under fraudulent pretenses, and then has tried to throw rocks at everybody else so that we won't notice the fraud that he's trying to pull over on his constituents. If you remember the last delegation meeting that we had, and he accused me of being the puppet master, and what I kept laughing to myself, and I was telling other people, he was right, but he was the puppet. And once again, he falls into that same category. And this takes a little bit of explaining. The law requires that JMSC screen candidate, Judicial Merit Selection Committee, that JMSC, and we can abbreviate as JMSC. JMSC screens candidates. When Halverson, I believe is the individual's name that he was talking about, when his nomination, when his paperwork comes to JMSC, at that point, and you're familiar with the process, in government, for something to happen, somebody has to make a motion. If it's a bill, somebody's got to put in a bill. Somebody wants to amend the bill, somebody has to put in an amendment. It doesn't just magically occur. Like if we have transparency, you'd be able to follow and track what's going on. When Halverson's name came up, at that point, with any other candidate in there, an individual has the opportunity to make a motion. I move that he be found qualified. I move that he be found unqualified. I move that we hold this, whatever it is. Nobody made a motion. Nobody moved to find him qualified. Nor is there any place in the law that requires anybody to do that. Senator Harpootlian, and this is why it's easy to be the puppet master with him, he reads the first paragraph. He doesn't ever read the whole law. Same thing he did back then in the meeting. So he's looking, going, nobody found him qualified. Nobody made a motion to find him qualified. But nor does the law mandate that Will Folks, because he sits on JMSC, has to say that Halverson's qualified if you don't think that he is.
Well, you know, Representative Justin Bamberg said at a hearing the other day that maybe they should put me on the panel. Would be a lot of fun, wouldn't it?
If they did, it would, right up until people started accusing you of being corrupt for following the law. Because following the law means that as long as the law is not going to require that you do things that you don't believe within your heart that you should do, like finding somebody qualified that is not, that you don't believe is, then the law is going to allow that his nomination, if that's what this is, fails because nobody wanted to find him qualified. Now, in that race, and again, Senator Harpootlian wouldn't understand this because he hadn't read far enough down. In that race, you had an incumbent judge, Bentley Price, who was found at that point. A motion was made to find him qualified, and I'm doing this off of memory, and it failed on a 5-5 vote, all right, because sometimes that would move a bill forward. In this case, it would not move his nomination for it, so it failed on a tie vote.
And I think the people of Charleston are safer because of it.
I disagree with you, but either way, it means that it clears that slate. So Halverson, even if he was found qualified, would not have been reported out. Senator Harpootlian, I know, does not know that. He doesn't read long enough to understand that. So the failure of a member of JMSC to nominate him to be qualified, Halverson, doesn't matter in the long scheme of things because Bentley Price was found unqualified because he wasn't found qualified. Does that make sense? And so it blanks the slate out, just giving you technical details surrounding it.
Speaking of things that do matter, and particularly from a public perception standpoint, is the broader allegation that people who appear before judges that they elect, that they appoint, that they screen through, is the argument that those lawyers should not then go appear before those judges, isn't that valid? I mean, isn't that common sense?
So the problem with that is it isolates one part of our system. And it isolates the part of that system that suggests that because Solicitor Brackett from York County, who tried to remove Judge Dan Hall several years ago and was unsuccessful in that attempt, that he then decided, well, if I can't do what I want to do, then the whole system must be corrupt. And so then that's where it gets started. Prior to that point, there was a newspaper that is fairly large. My understanding was they had a $100,000 grant to look into the process of judicial corruption. They found nothing. I am very proud of this.
We could have used that grant. We would have found plenty.
I don't know that you could have, but you certainly probably could have used it because this is a very nice thing and you could have paid for some lights in it. But the bigger issue is I'm proud of the system that we have. And remember, I came in back in 1998, and a lot of the positions that I have now I didn't have back then. I was one that tried to change the caps on judges. I didn't believe that we needed the caps. Right now, there's a cap of 3 people that are reported out of JMSC. I thought that needed to change. I've changed my opinion. I'll come back to that. But the judges that we put out are some of the best in the country, and they are not beholden to anyone. The suggestion that a judge is going to see somebody in front of them and is going to, because of the way that they feel about that person, that they're going to rule for them every time, or rule for them enough that it skews the balance. Does that mean that a judge that worked in a law firm at some point in the past should never be able to hear those cases? If so, then we'll take that as a notch. Does that mean that a judge that plays golf with lawyers, and he plays golf a lot, should that judge not hear those cases? Let's mark those. Should a judge not be able to hear cases from their former law clerks? Let's mark those as well. Should a judge not be able to hear a case from somebody that he doesn't like? Let's mark those as well. At some point, you have to have a system where a judge takes an oath and she says, I'm going to listen to this case and find on the merits. The fact that I've been on JMSC now for 10 years, the fact that I've been a lawyer legislator now for the past 25 years, if that meant that I won every single case that I took in front of, I'd be standing here going, oh, yes, I'm the greatest, I'm the best. But it simply is not true. When I win a case, I win on its merits. If I lose a case, I lose probably because the judge did not see it the way that I saw it, and he's wrong or she's wrong. I mean, just, but the reality is there's no lawyer legislator that wins every single case. There's no golfing buddy of a judge that I know of that wins every single case. There's no former law clerk that wins every single case. You are not going to take that out of the system. When the solicitors were tasked with coming up with examples, what that allowed them to do was isolate. Well, this lawyer legislator did this lawyer legislator did that. But I remember being a prosecutor. One of the things that they should have never allowed me to do was peep under the tent and actually be a prosecutor. And being told back then, I don't know that you want to try this case against this lawyer. This lawyer is not a lawyer legislator. I don't know that I knew what a lawyer legislator was back then. It was just some friend of somebody's that maybe nobody wanted to toy with. Lee Levinas is one of the best lawyers out there. Lee Levinas is a great friend of mine. A lot of people call him the Godfather. Lee Levinas has represented almost every police officer out there. He's represented so many people, the nicest people. I see him today asking about my kids, how they're doing, probably knows what grade they're in. When Lee Levinas showed up to court one time in Lower Richland, they couldn't pick a jury because he knew everybody on the jury. So does that mean that he's corrupt? No. It just means that he's a likable guy that does a great job at what he does. If we go back to any particular case that you have of mine, I can show you line for line why I've done what I've done. Maybe I impressed the judge. Maybe it swayed their opinion on something. Maybe I impressed the prosecutor. In every single case that we can talk about that has been enumerated in their testimony or talked about on the news, nothing that I did wrong, nothing that any judge did wrong. They didn't like it as my adversaries. But I don't like a lot of things that they do as my adversaries either. And a lot of the stuff that they have done has been called to the carpet by the Supreme Court. A lot of the delays that they've talked about came out of Lexington County in the Langford case because they wouldn't give somebody a fair trial. They want to complain about delays, but they're the ones that call the docket. What makes them upset is they can't always reach lawyer legislators because we're in session. So again, I can go back to the caps. I can go wherever you want the conversation to go.
But I will concede the point. You were a skilled litigator who has doubtless won many cases on the merit.
To them, it is only because I'm on JMSC. So I appreciate you doing that,
but I will
recognize
not concede your contention that these garden variety conflicts, Lee Levinas doesn't appoint judges. He doesn't pick judges. He doesn't screen judges to go before the legislature.
And yet he still gets what he wants.
But
But that's my point. But go ahead.
fair enough. But I also don't want to concede that those conflicts are equivalent to someone having the authority to pick and choose whether someone stays in their office, to set their budget, to set their salary. That isn't a level of power that any other lawyer will never have. But let's jump into some.
But let's go back to that, because sitting judges, by and large, are voted on by JMSC, are typically passed out. Sitting judges come in front of the General Assembly and are by and large passed out. And so it shakes at that suggestion that they're so afraid and shaking in their boots because a member of JMSC is here, when by and large they get passed out routinely. And so the suggestion being that they're so afraid that they won't get passed out by 170 people, 170, that they're going to give JMSC members and lawyer legislators what they want. It's a fallacy. It's a fallacy. What I see more often than not is they're afraid when Alan Wilson enters the courtroom, when the solicitor, when Rick Hubbard enters the courtroom in Lexington, when the sheriff comes and says, this is a bad guy, that's when all of a sudden they go, oh my God, well, the sheriff said he's a bad guy, and the sheriff is here, and the chief of police is here, and the solicitor's here. That's when all of a sudden they go, oh my God, I got to do something. Stop that. Keep them out of the courtrooms. Stop solicitors from being able to call cases, because that gives them immense power that they have abused over the years. The Supreme Court has simply not figured out how to tamp down on that abuse. But it is noted in the Langford case. There is no case out there that says lawyer legislator X abuses privilege and so now needs to be called to the carpet. So.
Not yet.
No, go ahead.
But I want to ask you about some of these cases, because I was in the courtroom for one of these cases, the Robert Marks case, where you argued very passionately against the law enforcement presence in the courtroom. But on the Robert Marks case, I want to talk about this. There was a pre-sentencing deal that was worked out with you and Judge Benjamin that basically delayed this guy's sentencing for years. After we had already waited years, and I spoke with the prosecutors about, you talked about that legislative privilege earlier, and they said, we can't get this guy in court to hear the plea. But, on the days that we're getting a plea that's favorable to the client, he's here.
Well, if a solicitor right now in Lexington County wants to call a case and they don't like the judge, you know what they do? Don't call it. If the solicitor right now likes the fact that this judge is going to be hard on drug cases, on marijuana cases, because he doesn't like marijuana, and they have a marijuana case and they want to call it, that is their authority, that is their ability to do that and manipulate the process, and it is done all the time. There was a report regarding Bentley Price that it was a case was 5 years old because they couldn't get an interpreter. Now, again, who couldn't find an interpreter? We have a language line. All you got to do is call them. They answer the phone. They'll send an interpreter. It ain't that hard, but the solicitor in Charleston didn't want to call the case, and that's why it didn't get called. So then Bentley Price goes, you all are violating this man's constitutional rights. I'm going to dismiss the case, and rightfully so. In the Langford case, the guy waited 6 years before the solicitors called this case to trial. There are, if you look at the old cases in South Carolina, the bulk of them are not lawyer legislator cases. So they need to stop acting as if we are clogging the docket. In that case in particular, you had someone that pled guilty, and going back to a conservative principle, a federal conservative principle, that Billy Wilkins was part of this process, a conservative Republican federal judge who created this sentencing commission. South Carolina was going to follow that process. And what the feds do is they do a pre-sentence investigation to give the judges more information so that the judge is looking at their background and knowing more about this person rather than the 2 minutes before pleading guilty. The fact that I know this is because I've been doing this for almost 30 years. The fact that, again, I'm using it, a tool that is available to anybody else out there, but they don't use it, that ain't my fault. If other people don't know the law, it's not my job to educate them. What you saw was my client pled guilty, the solicitor's there. We asked for a pre-sentence investigation so the judge can know more. The judge says, I'll order that. Probation, go start digging into it, look at his background. And then this person that's already pled simply hasn't been sentenced. Now, when he got sentenced, I think the sheriff showed up, all these law enforcement officers show up to tell the judge, oh, he's really a bad guy, even though he's been out for 6 years and he hadn't committed another crime. He's such a bad guy because he was a willing seller to willing buyers. And so we need to use state money, $32,000 a year of state money, to lock him up. Well, that's stupid. And again, I can't remember exactly what the judge gave him. You were there. Maybe you remember.
7 years.
7 years times $32,000 a year. We're spending $210,000 to incarcerate somebody that for 6 years didn't get in any trouble. That's stupid. Our drug laws are ridiculous. And again, anything that I can do to be a fly in that ointment, that's what I'm going to do. Legislatively, lawyerly, and just as a person, if it takes me holding up a picket sign, that's ridiculous. But back to, again, there's nothing wrong with asking for a pre-sentence investigation. Nothing at all. He had already pled guilty. He said he was guilty. So then he got sentenced. What's the problem?
The problem is that the report that you requested was ready within 2 months, and it still took over 2.5 years to get you in court.
No, because again, probation having that report ready, and then probation getting it to me seeing it and knowing it's ready. And then by
Mr.
the
Leader,
same
due
token,
respect, we've seen the emails where you invoked your legislative privilege to avoid having to appear in court on this matter.
because what you're not seeing is the fact that if they are trying to schedule court when I am in the legislature, there's nothing I can do about it. There are a number of people that don't know that the General Assembly meets typically from January to June. A number of people that get the pleasure of going on about their lives without worrying about when we're in session.
Oh, these emails were in September, but
But again, if they also don't know that because I've been there for 25 years, my time does not just stop when the General Assembly gets out. I am there Mondays, Fridays, Saturdays, Sundays, getting called to do
you
this,
have to go to
getting
the
called
panel
do that.
to pick the judges.
So, but again, it's one of those things where my schedule is no different than other lawyers that are doing other things. And so everybody is not available. And as a lawyer, what I am bound by is what a judge tells me to do. When I had my last son, my son is 2 years old, I could not get any parental leave to go and be with my son. None, because a judge refused to grant it. And this was in December. Denied, didn't sign. Nobody's going to come and help me with that. This is something that I have to deal with. And so my schedule is my schedule. Just like I'm here today. I got to go pick my son up. Don't know what time it is. Hope I'm not late doing that. But all of us have stuff to do. And the longer you've been there, the more you get drawn into having things to do. They know that. They knew that. There should be no complaint about the fact that somebody had already pled guilty and then eventually got 7 years. I don't see what the issue is. The state wants to spend $210,000 on that. So be it.
We're going to get to the big case in a second, but before we do that, I wanted to ask you, you pointed out solicitors not calling cases because they didn't want them to be heard in front of certain judges, but I have to ask you this point. We did a FOIA up in York County on a murder case, a murderer who is currently free now on bond. Former sheriff's deputy, white deputy, beat a man to death, allegedly, out on bond, and the reason, according to the family, the victims, is that you manipulated the system and the docket to get in front of a particular judge so that you could argue his bond. And again, this is not us pulling it out of our ass. Again, Mr. Leader, these are jailhouse calls where the mother of the defendant is saying this.
So, again,
this is the Evan Hawthorne case.
Evan Hawthorne is a former police officer who is in Rock Hill and is alleged to have killed another former police officer who they didn't work together, didn't know one another. And the individual that he is alleged to have killed is the former SWAT commander from that area, and the victim had drugs in his system, had alcohol in his system. They were both drunk in a bar prior to this. And my client, according to all the evidence, ended up in the victim's apartment and something went haywire. He was helped up to the victim's apartment by the victim's friends. And whatever went haywire, it is clear to me from looking at the evidence that my client was probably in the bathroom trying to get out while the victim tried to get in because he was found laying on his back right outside the bathroom. We have a stand your ground law in South Carolina that allows someone to defend themselves as long as they are acting in a reasonable manner. My client, Evan Hawthorne, suggests he was acting in a reasonable manner, and I believe the evidence backs that up. He's a former law enforcement officer. He had no prior record.
But why not argue that in front of the judge that you were scheduled to argue instead of getting the judge you...
There was no judge I was scheduled to argue in front of. This is a bond motion. You make a motion, and when you can do it, that's when you go. And even when this motion was supposed to be heard, I was told no, because the victim's daughter, I believe, was in college and taking exams at the time. But again, this is someone that had been in jail, a person with no prior record, accused of a crime that he alleges that, again, the evidence backs up that he was acting within the law, who's been sitting in jail for almost a year. How long should he wait? And so it gets to the point where people are playing games with trying to schedule stuff. It's not me because I don't have the ability to say tomorrow we're going to do X, Y, and Z. They say no. You'll see that in other cases as well. All I can do is file to protect the Constitution and the rights of individuals, somebody with no prior record who should not be sitting in jail. And the suggestion that because they say he's bad, he needs to be sitting in jail is farce and ridiculous. People with no prior record deserve to get out on bond, and routinely that's what happened, and that's what happened in this case.
Let's talk about the big case now, the one that generated statewide attention. As you recall, April of last year, our media outlet exclusively reported on the extra-legal, unconstitutional release of Jared J. Price, a gang leader, a convicted killer who, by the way,
Not extra legal, not any of those adjectives, but I'll
35-year sentence, a mandatory minimum, 35-year sentence handed down by black judge Reggie Lloyd, former chief of SLED.
I don't know what the point of what the fact that he's black has to do with anything.
Well, we'll get into that with one of the other questions that you raised, a racism allegation, but we'll get into that in a minute. But let me ask you about this case. You argued in front of the justices of the Supreme Court. You have been high profile in this case. This is the case that to most folks looking at this system strikes them as the biggest travesty of justice. This guy, a 35-year mandatory minimum sentence, released with 16 years left on that.
35-year sentence, 30 years minimum mandatory, 35. He got 35.
Fair enough. But released with 16 years left on him, 15, 16 years left.
Right.
Let me ask you this. Do we have a mandatory minimum law in South Carolina or not?
So here's the thing. And let me back up a little bit so that people can understand the full. And this is the transcript, so I can show it to you.
Okay.
Unlike what they're saying, I can back up what I'm saying.
Fair enough.
Gerard Price was convicted of murder. He went to trial on a murder charge because this was a case where the allegation was that he was a Blood and that the victim was a Crip. The victim was a Crip football player who went to USC, who stood about 6'3", weighed 280 pounds, according to the transcript. I never had the pleasure of meeting him, seeing him, don't know anything about him except what the prosecutor is saying, and these are verified in the transcript. The victim in this case got into an argument with his girlfriend that night, got into an argument with some other alleged gang members that night, and then, according to the witness that the prosecutor called up, the victim in this case towered over Mr. Price, lunged for him, and the gun that Mr. Price had in his waistband, another individual shot the victim, and then Mr. Price shot the victim twice as well and then ran off. So that's the case that we're talking about. We're talking about the death of a Crips gang member, football player who had been in 2 previous incidents involving other people that night. His girlfriend had to get the police to go and get her keys from him because she wouldn't go back in the club to do it. Another time where he was Crip walking, antagonizing, according to the police officer that Mr. Pasco called, antagonizing the other people in the club. And so then he lunges at Mr. Price, and somehow, I guess Mr. Price gets the better of it, gets his gun, shoots him twice. For that, Judge Lloyd, who was one of the toughest sentencing judges that South Carolina has ever seen, gave somebody 300 years one time, gave Mr. Price 35 years. 35 years. Fast forward. Mr. Price helps out a correctional officer in the Department of Corrections. Helps out another correctional officer in the Department of Corrections. The law requires the Department of Corrections to send that information. They can't just keep it and say, oh, yeah, we know he did that. We're not going to say it. They have to put that in his file. Wasn't done. Mr. Price hires me because he was being sent to Arizona. Couldn't figure out any reason for him to be sent to Arizona. So he's being housed in Arizona. He has a hearing coming up in South Carolina, and he said, I want you to come see this. So I do.
Gotta have some pull to get you to come to a hearing.
No, well, because I just had to see what's really going on. The state of South Carolina sent a plane.
It's not because he's one of the most prominent leaders of that gang?
Again, but based on them saying that, the reality is, what's in his file?
Fair enough.
It ain't there. But the reality, the state sent a plane to go get him and bring him back. We spent that kind of money to bring him back. I show up to his PCR here. There are correctional officers all around the courtroom. I said, Judge, we have deputies here. How much are they spending for somebody on their PCR. He then calls me. He said, Todd, there's a guy, and I can't remember the dorm. I apologize. Can't remember the prison. There's a guy in this dorm, in this prison. He's been gone for 2 days. They just did count again, and they don't know he's gone. I said, are you sure? He said, I'm positive. Called the Department of Corrections. Do y'all have somebody missing? Because I got to verify that they don't know anybody's missing. No, we don't. Yes, you do. Here's the dorm. Here's where he is, and he's gone. 2 minutes pass by. They call me back. You're right. What else do you know? That's all I got.
This is Jimmy Causey, the famous
Jimmy Causey,
Yeah.
who tied up Jack Swirling, who's a local famous lawyer, statewide lawyer.
Absolutely.
Tied him up, had already escaped from the Department of Corrections, was out on a bank robbery when he did this to Jack Swirling, all around bad guy.
Bad dude. Absolutely.
So they called back. They then verified that I had talked to Gerard Price. They knew who gave me the information. They verified that. They found Jimmy Causey maybe 2 or 3 days later at the Mexican border with guns and drugs. He later stated his intent was to come back and find Jack Swirling. So again, doing a service for the state of South Carolina, if you are an informant and they catch you with drugs and you then go and tell them who you bought drugs from and buy drugs from, and the state goes in and arrest that guy, by law, they have a right to keep your identity secret. It's a statute. It's in the law. Mr. Price, in prison, had given information about an escaped inmate while after also helping 2 correctional officers. He had done all these things. And so at that point, the Department of Corrections, me talking to them saying, what are you going to do for him? Because the law allows you all to do something. It allows you to send a letter to the solicitor stating, hey, he's entitled to a reduction. The solicitor, for years, because this happened a while ago. I can't remember the exact year that Jimmy Causey escaped, but this was a long time ago. I go to the solicitor. Can we go and talk to the judge, like I've done in other sentencing reduction cases, about what Mr. Price can get for what he did? Sure, let's do that. Now, mind you, it's improper for me to go talk to a judge without the solicitor. That's called an ex parte conversation. You can't do it. It would be unlawful for me to do that, okay? Unethical. So the solicitor and I go, we talk to the judge, and as was stated in front of the Supreme Court, and as I've said a million times, the judge says, solicitor, what do you want? In a lot of cases like that, the solicitor says the same thing. It's not really my deal because it happened inside the Department of Corrections. This is what he did. And the judge determines what he ought to get. Now, any judge with any degree of sense, but especially this one who had been practicing for a long time, one of the smartest judges we would ever have in South Carolina, he knows to give Gerard Price a sentence that leaves him in the Department of Corrections means he ain't gonna make it out. Or he's going to be treated the way that they treat him now, where he has absolutely no rights. None. He's in solitary confinement because they're so afraid something's gonna happen to him, they'll get a bad name. Well, to a lot of people, that's worse than death. But either way, so he has helped out 2 guards. He's given information about a dangerous prisoner that had already escaped once before and has escaped once again. What is he entitled to when one of the toughest judges in this state that we've ever had gave him 35 years on a murder when he killed a rival gang member? Judge Manning determined after back and forth that it should be taking off or giving him credit for the time that he already served and cutting off the last of his sentence. To what your statement is about the mandatory minimums. Mandatory minimums exist throughout our system. They exist in the federal court and in the state court. When we passed the sentencing reduction statute, as I stated when I went from Supreme Court, we did not say the mandatory minimum cannot be breached. We didn't do that for a reason, because the feds don't do that either. Giving information is what allows a prosecutor to go below the mandatory minimum. And when the federal government does it, the FBI, DEA sends a letter to the judge, hey, this guy cooperated, we were able to make these 10 arrests, and the guy gets a notice. The judge reduced your sentence. There's no hearing. Nobody else comes in. It's just the judge does it. In the other sentencing reduction cases that I've done, that's exactly how it was done in one of them. In another one, we had to wait until we could send a private investigator to look for the victims. But in this case, this judge, Judge Manning, was retiring. Obviously doesn't give a damn about JMSC and getting screened again. This is about justice for somebody that helped out in a serious case to potentially save the life of a upstanding lawyer in this state. Now, we can argue about exactly what it should have been, and maybe it should have been 5 years. Maybe it shouldn't have been anything. We just give them a ham sandwich and tell them to go back. The problem is we make our entire system less safe when we do that, because other inmates need to be incentivized to cooperate and give that information, which helps out correctional officers and helps out the system. And again, it follows the law because it allows the solicitor to protect the identity of the informant. What did we do in a case where Gerard Price killed a rival gang member who had argued with 2 other people in the club, one of them being his girlfriend, who was afraid to go and talk to him after that? Reduced his sentence. Again, the solicitor in that case failed to file the document. And that is how we all get to be where we are. There are persons right now who give information about murders, drugs, rapes, all kind of things that prosecutors have in their clutch that they don't have to disclose, and that they can help out routinely, reducing sentences, moving them here and there, because it gives them the ability to do so. What happened in this case was because the solicitor didn't file the notice, the attorney general was able to step in and say, oh, well, I'm the state, and even though he's with me and part of me, he messed up, but I get to come in and take advantage of that error. Never happened before. But so that's how we got here.
But you talk about disclosure. You talk about the back and forth in that case. You talk about the alleged services that Gerard Price is said to have performed to the state of South Carolina. Obviously, we have information that there were some alleged threats Gerard Price made to some of the wardens at the correctional institutions where he was housed. But let me ask you this. Let's assume there's a basis in fact for what you're saying about his material assistance. Let's assume there's a basis in fact about the allegations against him while he was in prison and his gang activities. Shouldn't all that be discussed in the open? And more importantly, Mr. Leader, let me ask you this. Shouldn't the victims in this case have a voice, or at the very least be aware that the murderer of their son is being turned out into the public 15 years before he should be?
So what I would argue, and what defense attorneys have argued for years, is exactly your point. The prosecutors should not be able to keep those secrets that they do.
So
all
you're
the
saying
time.
it was Solicitor Gibson is the reason this was secret?
No, what I'm saying is that that's law enforcement. Law enforcement keeps these secrets all the time. Who is cooperating with law enforcement? Who's going out there making buys? The records are replete with defense attorneys saying, give us the name of this person you say did all these things. No, we're not going to turn that over. Well, I argue that it should be turned over. I argue that they should not be able to keep these same secrets that they keep routinely day in and day out on what cooperators and undercover people that they have out there. There shouldn't be any secrets. And you know, I'm big on no secrets in government. But here, this is the law. The law allows them to keep informants' names secret. The law certainly allows them to protect the identity of someone that gave information that is helpful. The law did not mandate that these victims be notified in advance because of the fear. And you go all the way back to, what's the notorious guy? Pee Wee Gaskins, who killed somebody in prison because a family member hired him to do it. So it's not like just because the victim's family of this gang member, 280-pound, 6'3" gang member that, again, had argued with other people in the club, does not have a right to be there. It's what the law says they should be entitled to.
But it's not just a right.
The law does not give them any expanded info that it doesn't give lawyers on the other side. And right now, we don't always have access to who the informants are, and in this system, neither did they.
Well, then you got to change the Constitution, because those folks had a constitutional right to know what happened behind those closed doors at the Richland County Courthouse. And again,
I think we all do. So you're right. No more secret informants. And they would never go for that. Never. They like their sources, and these people give me information. Well, can you give me his rap sheet? No, it'd have his name on it. It's 30 pages long, but you don't need to know that he's the guy that went out and made buys and is giving us good information. Stop all of that. I am perfectly fine with that, and most defense lawyers would be as well. But the reality is it can't be good for them when they want it and bad for them when it's used against them.
I want to ask you one more question, because we talked earlier about race, and you pushed back a little bit when I referenced Judge.
Because it wasn't material to the story. I mean, he's a judge.
But let me
he's
ask,
a tough judge.
I want to ask you this question, though. There were a group of solicitors citing a number of these cases that called for you to be removed from the Judicial Merit Selection Commission. They called for the House Speaker, Merle Smith, to take you off of that panel. Obviously, Speaker Smith has not done that. But among those solicitors was Chip Finney in Sumter, the son of the first black Supreme Court justice here in South Carolina. But you called those solicitors racist, and I just wanted to get your thought on how is that possible if one of the solicitors who signed the letter is black, and not only that, the son of one of the most trailblazing black jurists in our state?
If what you're doing is picking out 1 out of 9, and you're taking it just at the point of the letter and not with what happened all prior to that, when you had 2 members of the 9 going out and giving speeches, and they still do. Now it's 3 of the 9 going out and giving speeches about how bad I am, how corrupt I am. He's a criminal defense lawyer. Well, how come they didn't mention all the other criminal defense lawyers that were on JMSC? How come they didn't mention that? Why is it that they continue to call me, oh, this powerful lawyer? Well, again, the reality is what they are trying to do is make me the boogeyman, which they've successfully done because now I guess I'm that guy. And the fact that one solicitor also signed on to that, that's his fault. But they know when you throw a rock into a crowd, the people that get hit are the ones that holler, the ones that got hit. And when I said they were using race, I meant it. And I meant it for those people that were using and continue to go out there and use me as the boogeyman when there are other people on the commission that also do criminal cases. Has nothing to do with the fact that I'm a lawyer. Has nothing to do with the fact that I'm a lawyer legislator. It is the fact that we didn't take Dan Hall off of the bench, and because of that, I am the best boogeyman they can find. I'm a black man in South Carolina that they can say has power, and a lot of people are going to hate that. And the more powerful they say I am, and the more they keep showing my face, there are a lot of people that are going to be upset with that, period. Whether Chip, what he knew when he signed the letter, I have no idea.
Fair enough. Mr. Leader, I do want to
because I am told that he did not know that it specifically applied to me. But again, I can't say that.
So you're saying that Solicitor Finney was misled in signing the letter?
I'm saying I wasn't there. I'm only saying that I have been told that he didn't know that they were only talking about me. He thought they were talking about the entire JMSC.
Fair enough.
But let me go back to something else, because one of the things that you referenced that upset me a great deal was about me being investigated. Because I went to SLED. Well, whatever lying idiot told you that, whatever they saw was me going in there by myself. I'm a criminal defense lawyer. I ain't going to talk to the police, period. I don't recommend that anybody go talk to the police. I certainly wouldn't mind that you go, I wouldn't recommend you going to talk to the police by yourself. You should have a lawyer if that's what you're planning on doing, which again, I wouldn't recommend. So again, people ought to stay in their lane and know what they're talking about, because saying that somebody's being investigated all of a sudden means that people don't want to talk to me. They think that I've done something wrong. I don't do stuff wrong. I don't drink. I don't smoke. I don't do drugs. Never have. Again, I'm not holier than thou. I don't read the Bible as much as I should. But again, I don't do stuff wrong because I can't sit up here and talk trash to law enforcement and say things like I say about prosecutors and police departments and that SLED ought to be broken up and decentralized and all these things, and then worry that they're going to find out that I've done something wrong. It doesn't make any sense. But not only that, it ain't true. And that's one of the biggest reasons why I wanted to come in here, because it doesn't need to go any further than this. And I wish they'd say their name on the record so I could sue them for what they said, because it is, for somebody in my position, it is the worst.
We published the allegation. You're more than welcome to file that lawsuit.
The difference with you is I'm a public figure, and I don't know where it came from, what it is, but an invitation to sue, I'd certainly take you up on that.
Well, I do have a order in my pocket saying I don't have to give up sources.
I'm with you on that. I've read that. I know that. And so what people need to understand is I am not being investigated. Again, I can't say that right now somebody's not out there driving by looking at my car because I'm here talking to Will Folks and they want to know who Will Folks' sources are. And so I don't know that, but I know what I know, which is nobody from SLED is interviewing me about any conduct that I have done that's illegal. I wouldn't do anything that was illegal, and I stand firm on that, period.
Well, one thing I do know is that I'm grateful to you for availing yourself of our microphones, because I hope you do understand that the way that we do things here, we take pretty direct shots. We've taken plenty at you. We asked you some very direct questions.
Yeah, I think like 100 or 20, but you can
in
call
this
it plenty.
interview. But yeah. I do appreciate the fact that, again, we talked about this at the coffee shop the other day. You've always been somebody that's willing to address them. I respect that tremendously. I appreciate you taking the time to come in here. I'm sure that we will be back at it again soon, but always
Let's
know.
legalize medical marijuana. Let's allow gaming. Let's take the government out of people's lives as much as we can.
Well, we
So,
need to
yes.
get you in here to talk about some of the legislative issues soon, but I am glad you took the time to come in and address these. Mr. Leader, always welcome here, and certainly when we're covering these stories, you're always welcome to come in here and present your perspective on it to our audience. That's what this is all about.
Appreciate it. Thank you.
Yes, sir.